I guess the other thing we can talk about is, directors who get a director penalty notice, what do they do? And I think, the clear message for that is engage, because what we can do is we can engage in two ways, depending on where the company's at. We either engage on the company's behalf and get the company into an active arrangement. And even though the director's got the director penalty notice, under the ATO policies, as we know, they won't pursue the director personally, whilst ever the company is then compliant in their arrangement.
I've got one at the moment that I'm helping a particular client where they actually had a director penalty notice about 2 months ago. So it has expired. They didn't know where to go. They didn't know what to do. And we're in the process of getting them into an active arrangement right now. And so once they are in that active arrangement, even though it's expired, it will have the practical effect that no further action will be taken against them personally.
Yeah, that's it. And that's the way. And I think people need to understand it's a parallel liability. So if the company deals with the debt, every dollar that's paid down by the company is a dollar that comes off the director's director penalty notice, to the extent that they're lined up. So it's really important. And I think the other one we've seen a bit of at the moment is, and I had one just last week, where directors have, their business has been in trouble and they've engaged with the liquidator. And we had one where they put the company into liquidation, but they didn't quite do it quickly enough. And there were a couple of director penalty notices that were issued. One was caught in the period where they were able to do it, but the larger one, unfortunately, wasn't. And again, the director had thought, well, look, if I put my company in liquidation, that's the end of it. And it wasn't in this case. But again, even in that situation, the company, went into liquidation, but the director was still able to trade himself, and we were able to then get him into an arrangement, stop any recovery action. He had his home in his own name. His wife and he were, very concerned. But look, it's an IT consulting company. They've got good clients, good client base. But again, like many businesses, got into trouble during COVID through no fault of their own, and had an otherwise strong business, and they took the opportunity, I guess, or the steps to actually put that company into liquidation. Then, sometimes that's necessary, but we saw it after that. We may have been able to even stop that for them, and I suspect we probably could have, but that's the decision they made. But even at that late stage where the company's into liquidation, we're still able to help the director to stop the ATO taking his home.
Yeah, absolutely. And when you talk about parallel liability, that also happens when there's two directors. So it's exactly the same concept. So sometimes we see where there is a director and there was a director's dispute, and one says, well, why should I have to pay it? He can pay it. But they're actually both still personally liable until it's completely paid off. And so that's really important to know, that if the company is no longer trading, but there was that personal liability, that won't go away just because there's a director dispute.
You can't put your head in the sand when this stuff happens. The director penalty notices have strict time frames around them, particularly ones where what they call a standard director penalty notice, whereby directors do have an opportunity to avoid liability, but you've got to act quickly, and you've got to act within those timeframes. And there's no wriggle room in those timeframes. So it's not a straightforward process. There's a couple of different types of director penalty notices. As you know, there's quite a lot of complexities around it, and people just need to get expert help.